Hello guys, this is Steno for All YouTube channel. Here we provide you Hindi or English shorthand dictations at different speed. Today I am going to provide you English dictation at the speed of 80 which will help you in various steno skill tests. So get ready. 1 2 3 4 5 Start. This appeal by special leave has been preferred against the judgment and order of the Bombay High Court, by which the latter's patent appeal filed by the bank was dismissed and the order passed by the learned single judge was affirmed. The present appeal has been filed by the bank and the respondents arrayed in the appeal are Union of India and the Federation. The case of the appellant is that the Federation is in the habit of backing out from signing the settlement at the last minute after having agreed to the terms thereof. On account of the recalcitrant attitude of the Federation in the settlement entered into under Section 18(1) of the Industrial Disputes Act 1947, a clause had to be incorporated for voluntary acceptance of the terms and conditions of such settlements by non-members of the association. Feeling aggrieved by the reference made by the central government to the Industrial Tribunal, the bank filed a writ petition under Article 226 of the Constitution before the Bombay High Court for quashing and setting aside the same. The writ petition was dismissed by a learned single judge and the appeal preferred against the said decision before the division bench also failed. The present appeal has been filed by the bank challenging the aforesaid orders. Learned senior counsel for the appellant bank has submitted that the reference made by the central government is wholly redundant. The language in which the reference has been couched clearly shows that the Federation merely wants a declaratory relief which by itself would be wholly ineffective and will give no benefit to the Federation. It was also contended that if the settlement arrived at on 18th August 1996 is held to be illegal or unjustified, it will result in causing serious injury to the appellant bank, as it will be impossible to recover the benefit which had already been given to the employees in terms of the settlement. A plain reading of the provisions of Section 18 would show that where a settlement is arrived at by agreement between the employer and the workman otherwise than in the course of conciliation proceeding shall be binding on the parties to the agreement in view of the clear language used in subsection thereof. Learned counsel for the Federation submitted that under the settlement, such employees of the bank who were not members of the association were required to give a receipt in writing in order to avail of the benefits of the settlement, and this was clearly illegal. We are unable to accept the submission made. We do not find anything wrong in the bank asking for a receipt from the aforesaid category of employees. The principal issue which requires consideration is whether the central government was justified in making a reference to the Industrial Tribunal in terms set out earlier. Section 2 K of the Act defines industrial dispute, and it means any dispute or difference between employers and employers. The definition uses the word dispute in Gujarat State Cooperative Land Development Bank Limited VPR, Mankad and others. It was held that the term dispute means a controversy having both positive and negative aspects. It postulates the assertion of a claim by one party and its denial by the other. A plain reading of the reference made by the central government would show that it does not refer to any dispute or apprehended dispute between the bank and the federation. The reference made by the central government for adjudication by the industrial tribunal is wholly redundant and uncalled for.